want to raise with the Minister today the issue of victims' rights for those people where the perpetrator of a crime committed against them is departing from a prison or an institution. Now, Minister, I suppose prior to being a TD, I was not aware of the very significant rights which exist under the Victims' Charter in terms of the right to know where a person is imprisoned, changes to their custody, changes to their location, and so on. And that applies both to prison, but also to those people who are in the forensic mental health services as well. I suppose difficult cases are difficult for a reason, and there was one constituent of mine, Fionnuala Bourke, who has approached me because of, I suppose, what is a gap between the system, and I'd like to raise it with you. I know I've raised it with you privately, and I'd like to do so here in the Dáil as well. Fionnuala was stabbed 9 times in a random attack by a stranger on her way home from work. A brutal assault, Minister, the scars of which that she still continues to live with. Look, this is well raised and rehearsed in the media and in public. And the perpetrator of that crime was convicted despite lodging a plea of guilty by insanity that was disregarded by the jury, and the perpetrator was found guilty, and there was a sentence sentence issued. And the judge in that case specifically mentioned the fact that while the jury had disregarded the plea of insanity, that they had that the person concerned, it was not the case that the person concerned may not have a mental illness. And in the judgment, he was very clear that of acknowledging that, but also acknowledging that the person was guilty and therefore should deserve the custodial sentence. Unfortunately, Fionnuala's perpetrator had also committed a similar attack 2 weeks earlier, and in that case, there was a successful determination that she was guilty by insanity, and therefore she was referred to the Central Mental Clinic, and she remains there. I suppose the grave difficulty is that, as far as Fionnuala is concerned, there was no sentence for the crime that was committed. The person concerned served her time in a health institution, as may be appropriate, but there was no prison sentence that was ever served. And she also received other difficulties. For example, she wasn't the victim of the crime for which the person was detained in the forensic mental health services, and so as a result she was entitled to no information in relation to when that person might be released, periods of leave, and so on. Now, I know this issue was raised with your predecessor, Minister, by a number of people, including myself, and the Minister did commit to examining whether legislation might be required or whether changes in practice may be required. But I suppose at the heart of it is sort of a huge feeling of injustice from Ms Bourke's perspective, that a crime, a very serious crime, was committed against her, that somebody was found guilty in a courtroom, that a sentence, a very significant sentence, was issued, that the person concerned hasn't and will not serve any period in custodial sentence, and remains sort of outside of the loop of information in regards to the detention. So I raise it with you here in the House, Minister, and I hope that you might be able to provide me with more information.
Thank you, Deputy. Before I call the Minister, I'd just like to caution that we should try, I know, notwithstanding the sensitivities of the case, avoid naming people who are not in the House. Minister.
Yeah, thanks very much, Cahirla. And I want to thank Deputy McAuliffe for raising this very important issue. And he's correct, he has raised this issue with me privately, so it doesn't come as a surprise to me. And he's correct in stating that the issues that have been identified have been very much raised in the media. Can I just at the outset say I commend you, Deputy, and I think it's important that we do take into account the position of victims in the criminal justice system. Historically, the criminal justice system was very much associated with determining the guilt or not guilt of the person who is accused of the offence, and probably insufficient recognition was given to the very significant challenges that victims have to overcome in order to get justice. Obviously, there's the trauma of the offence itself. You've outlined it in respect of the person who's raised the issue with you, then having to make the complaint to an Garda Síochána. I have to say, victims in general, when I'm speaking to them, give me a very positive account of their engagement within Garda Síochána. Then there's the issue in terms of the Gardaí having to investigate. That necessarily takes time. The Gardaí have to put together a file. The file goes to the DPP, and that can be a traumatic time for a victim determining whether or not there'll be a prosecution or not. Of course, if the DPP does decide to prosecute, then the really important part of the victim's function is that they have to give evidence in the court, and that can be a challenging experience. And then, if they get the conviction, that is the stage when we say that the state has delivered justice for the individual concerned. You're talking, Deputy, about circumstances that arise post-conviction. In general, justice is delivered for serious crimes such as the ones you've identified when a person receives a sentence of incarceration. I fully recognise that prison is not the only solution to serious offences, but it's certainly part of the solution, whether for the purpose of punishment and indeed rehabilitation. We have very significant legislation in place in Ireland to protect and enhance victims' rights. You'll be aware of the criminal justice victims of crime legislation, which does give rights to individuals. You'll be aware of the Parole Act that I was instrumental in getting enacted, which also gives rights to individuals in respect of victims seeking justice when it comes to their perpetrators seeking parole. The issue you identified, Deputy, very much relates to issues that I think can be categorised about when are concurrent sentences imposed as opposed to the imposition of consecutive sentences. In the case you have outlined, perhaps the injustice that your constituent feels may have been resolved if it was the case that the sentence that was imposed in respect of her case was a sentence that would commence after she was released in respect of the other offence for which she was found not guilty on grounds of insanity. In terms of victims of people when they're detained in institutions such as the Central Mental Hospital, that's obviously a designated centre under the Criminal Law and Sanity Act 2006, and it's part, as you know, of the National Forensic Mental Health Service, provides a range of forensic mental health services to its patients. People who are victims of offences perpetrated by individuals who are retained within, say, the Central Mental Hospital, they can register with the National Forensic Mental Health Service Victim Liaison Officer. But I have to say to you, I'm not disowning responsibility. That's a responsibility that doesn't come within my department. It relies elsewhere. The department has no involvement in that in respect of the Department of Justice. In terms of what is required in the future, obviously the circumstances of your constituent's case are very harrowing. They're also, I have to say, unusual. And that may be of cold comfort to her. But I suppose you have to be careful about legislating for the exceptional case. But I do think the resolution is in terms of the ability that's there at present for a consecutive sentence to be imposed as opposed to concurrent.
Minister, Deputy.
Yeah, look, and I appreciate, Minister, that often matters that are before the court are in the control of the judiciary, and I suppose there's a very clear separation of powers between what happens in this House and in terms of what happens in a court and how decisions are made in a court. I suppose as Fionnuala sat across from me at my clinic, and she was there for some time, I suppose I could only agree with her in her sense that she feels that a crime was committed, that while justice was administered and there was a process for dealing with all of that, the ultimate outcome of the sanction of a custodial sentence was never served. And I suppose there's probably no way of releasing Fionnuala from the view that that injustice stands, because I think it's a very reasonable thing for any victim to hear of. I suppose we can't go back, the court case can't be changed in any way, but I do think, Minister, it's worth looking, and as you say, I accept it's very unique, it's a very particular set of circumstances, but as we go forward, as we as we examine the interaction between mental health and custodial sentences, I think it is something that I'd like you to dwell on. I suppose that we don't forget the experience of Fionnuala Bourke, because she lives with it every single day. I do particularly think that in relation to access to information, where there is a concurrent sentence, there is a gap there where access to information should be provided to the victim, although I do believe that in some ways Fionnuala has come to terms with that. It's a harrowing prospect, the idea that you don't know when somebody might be released, that you don't know when you might meet that person again, that person who has, may have made threats against you, you might experience them or interact with them again. That's why we have the Victims' Charters, to prevent that. And in this case, there isn't a process for this. I think that is an area that we could look at, but I understand it's a difficult and tricky case.
Yeah, I just want to acknowledge and agree with you, Deputy. Like, what happened to Fionnuala Bourke was a harrowing and a desperately traumatic crime that was perpetrated on her. What happened is that the perpetrator, who received a sentence and justice was done, my understanding, didn't commence that sentence because at the time they were being detained within the Central Mental Hospital. So I suppose the state, what happened in this instance was there was detention, but not a detention on the basis of the guilt of the perpetrator because of the crime they committed against Fionnuala. Potentially, that could have been resolved through the imposition of a concurrent sentence. I'm not sure in terms of the timings as to which offence was dealt with first, but I will have a look at it within the department, Deputy. But I just don't want to mislead you or indicate to you, or more importantly to Fionnuala, that there's a simple solution that can be put in place to resolve this. I don't think it is. It's a highly unusual case, but she is certainly entitled as a victim to be given information in respect of when her perpetrator is to be out in the public again. That's something that I certainly think she is entitled to, and I hope there are mechanisms in place to ensure that can be achieved. In many instances, it is very traumatic for individuals to find that the person responsible for the serious offence against them is back out in the community. I know one of the tools that prison service that I have in my availability, and indeed the courts have as well, is to provide sort of exclusion zones or to grant release on certain grounds and conditions. Those conditions, certainly in respect of very serious offences, can result in people being prevented from going into certain areas. Obviously, that is an issue of some complexity and has to be exercised sensitively, but it does recognise that there is a deep concern on our part to ensure that victims are protected from the ongoing damage caused to them by such offences.